Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate here at Samfiru, Tumarkin, the employment lawyers. I'm the managing associate of our Calgary office here in beautiful Alberta. If you have any questions related to Calgary or to Alberta laws as they relate to employment law, I'm your man. I also know a lot about both Ontario and BC law, so feel free to ask questions if you're in those provinces. As we start off today, I wanted to talk to you a little bit about a conversation I had with a very nice woman last week. She had asked me to review her employer's new employment contract, and she wanted to know whether she should sign this contract. So I applaud her for doing the right thing, which is if you're presented with a new employment contract after you've started working, reach out to a lawyer, reach out to us, have it reviewed. All right. There was a lot in that contract that was very problematic. All right. Of course, it had, a termination clause where she never had a termination clause in the past. It had a non-defamation clause so that you couldn't badmouth the employer, which was concerning as well, because generally, you have free speech unless you sign that away. And also, she would have to agree to let the employer get an injunction if she did badmouth them. So an injunction, you might not know what that is. Essentially, it's a court order ordering you to do or not do something. All right. What's serious about it is that if you breach that injunction, you'll be found in contempt of court, and potentially you could be sent to jail for being in contempt of court. So essentially, the employer was asking her to agree to let a judge send her to jail potentially for exercising her right of free speech. So I'm reading that, I'm like, wow, that's quite onerous. I don't know if I can recommend that you sign that. And I asked myself, what was she going to get in exchange for signing this contract? Because you got to remember, a contract should be a two-way street. And just being and the employer continuing to employ you is not what you get out of the deal. The employer has an obligation to continue to employ you or pay you severance. All right. So just continuing to employ you is not a fair trade. All right. You already have the job. Okay. They were basically offering her nothing in exchange for signing this contract, signing away these important protections to her rights. And so I told her, don't sign that contract. Absolutely. You want to stay away from that. Every employee, whether they have a written employment contract or not, has certain terms built into their contract by the law that surrounds us all. All right. So you don't need a written employment contract to have a contract between you and your employer. And in fact, this contract, weirdly, is found in the laws of the land. All right. There are certain laws of the land that speak to work. And one reason employers use employment contracts is to contract out of these laws of the land. In some cases, it's legal. In other cases, it's not. But in some cases, it definitely is. Like, you can agree to an injunction. You can agree to a termination clause. And if these clauses are valid and the contract is valid, then you're stuck with that, right? But if you don't agree to that, then your right of free speech is not amended. Your terminational entitlements are not amended. So you want to sign that away only if you're really getting something good in exchange, right? And especially for termination clauses, I'd be careful. Say you're a 10-year person, you might be entitled to 10 months of severance. Whereas here in Alberta, if you sign a termination clause that limits your entitlements to what's provided in the Employment Standards Code, then you're only going to get 8 weeks, even though you've been terminated you've been working for 10 years. So you've gone from 10 months to 8 weeks. 8 weeks is less than 2 months. So you've cut your termination entitlements by 5 times, right? You're basically agreeing to take 20 cents on the dollar. Why would you do that? Right? And how many times have I seen it? You get a contract saying, well, listen, we'll give you a $3 an hour raise. You sign this contract, we'll give you $300 an hour raise. We'll give you $350 as a signing bonus, whatever it is. You sign the contract. Now they can terminate you for 20 cents on the dollar. And what happens? They actually do that, right? And now you've signed the contract, and it's become a big complication to get you out of that contract. So be careful when you're being presented with a new employment contract. Keep an eye out for termination clauses. If you didn't have a termination clause before, and now they're asking you to sign a termination clause, you might be giving up a lot of money potentially down the road if they decide to terminate you. And in fact, employees think, well, if I don't sign them, they are going to terminate me. If they owe you 10 months, they're not going to terminate you so quickly. If they only owe you 8 weeks, it's a much easier decision for them to terminate you, pay you 8 weeks, and be done with you. But if you're owed 10 months, that could be worth 50, that could be worth 100. That's a lot of money for a lot of employers. So they got to think long and hard whether they can afford to do that, seeing as they need you. And they might not do it if the only gripe they have against you is that you haven't signed an employment contract. All right, so be careful about that. All right, we have a question from the audience here. Thanks everyone for tuning in. Once again, I'm Lluc Cerda. I'm a senior associate here at Samfiru Tumarkin, where I'm based out of Calgary, Alberta. So I have a question from Bruce Bobtrotter. How much do lawyers make straight out of law school? Is it true that they're making $100K right out of law school? That's a good question. There's a lot of variation in terms of lawyer compensation, depending on the firm that you work at and all of that. So it varies a lot. All right. We have another question coming in from Rocket on YouTube. If it can be proven that I was not hired because of my vaccine status, is that a human rights violation, and can you pursue damages? So, Rocket, potentially. So basically, the right to be free from discrimination in employment affects all aspects of employment, including hiring. All right. So if hiring is based on discriminatory grounds, then you also have a claim under the Human Rights Tribunal. Absolutely. We have a question from Lisa on YouTube. Can an insurance company dictate when your return to work plan starts? I thought a person on LTD was in the care of their doctor who recommends when they should be returning to work. What are my rights? Yes. Sorry about that. I was just double checking that answer. So essentially, LTD is not necessarily requiring you to return to work. They're basically telling you what will happen if you don't, which is that you will be cut off from LTD. All right. Now, you're right. Absolutely. You're in the care of your doctor. It should be your doctor making that decision. So speak to your doctor if you don't think you're able to return to work. All right. Because you have to be ready to return to work and your doctor has to agree with you. So I don't know where LTD got the notion that you were ready to return to work if your doctor is saying that you're not. So definitely you want to speak to your doctor about why they think that you can return to work. It's a bit unusual that the LTD company would require you to return even though your doctor says you're not able to return. A lot of people can return to work, but with restrictions. All right, which means essentially, I can't lift a certain amount, or I have to, have frequent breaks for whatever reason. That means you can return to work, and your LTD provider will say, well, go back to work, and your employer has to provide you with those restrictions because you are able to work. So it kind of depends. Are you completely disabled that you can't work at all? You can't work in any capacity, no matter what restrictions or what accommodations are provided? Or is it that you can work so long as your restrictions are met? In which case, generally, the employer, the LTD provider will ask you to go back to work. We have another question from Lisa on YouTube. That's the question we got from Lisa. All right. Yes, so we just answered. Okay, so we got a question from Bill Sullivan. Policy manuals. Am I correct in assuming consideration must flow between employer and employee for the manual to be legally binding? I.e., each party must gain something to be legally binding. So this goes back to contracts that I was saying before. Usually contracts are a two-way street, all right? And in fact, for a contract to be valid, there's got to be what Bill calls an exchange of consideration, which is the legal term. All right, so imagine, you go buy a pack of gum, there's a contract there, believe it or not. You didn't sign anything, but there's an implied contract there. You paid $2, and in exchange you got gun. So each, you and the corner store each got something out of that transaction. Now, if you go to the corner store and just give them $2, all right, and don't get anything in exchange, that $2 is essentially a gift, and gifts are unenforceable in court. All right, so the corner store can't go and tell a judge, well, listen, he gave me that $2, that's my $2. All right. In essence, though, how it applies to the question of contracts is you're promising something. You're not giving $2. You're promising something. So it's like going to the corner store and saying, I'm going to give you $2 in a month. And a month comes and you don't pay the $2. They can't go to court to force you to pay that $2 because that's a gift. If you had gotten a pack of gum in exchange, then that's a legally enforceable promise. They can ask the judge to order you to pay that $2. Same goes for contracts. So you're signing away all these rights that you had, termination clauses, and all of that. And you don't get anything in exchange, be it a signing bonus, a raise, or anything like that. You just promised to be bound by this contract and got nothing in exchange. That's an unenforceable contract. Now, what happens is that employers oftentimes will present to you either at the start of your job or midway through it with a policy manual. Now, policy manuals are not so much promises, or not all policies are the promises that we describe. So policy manuals can differ from one company to another. They might simply explain what happens if there's a claim of harassment in the workplace. What harassment is, how it will be investigated. They might have, a policy on overtime pay, on how you claim overtime, how you get authorization for overtime. These are just policies, but sometimes in policies they have more serious things. Like sometimes the termination clause will be buried in the policy manual. So there's that. It's been happening a lot with COVID and COVID vaccine mandates that essentially the policy is updated, and now the employer is saying you're bound by our updated policy. Whereas, as Bill says, that's up for debate essentially, because firstly, you weren't hired on the basis of that policy because COVID wasn't around back then. So it's hard for you to explicitly agree that you'll get the COVID vaccine when no one's even discovered COVID yet. So relying on the policy is fraught with complications for the employer. On the issue of consideration, Bill, I would say in classic lawyer speak, it kind of depends. All right, it depends which policy really you are taking issue with. If it's one of those policies that limits your entitlements, then yes, I would say, if you're making $30 an hour, now there's a policy on pay rates, and it says that someone with your years of service is entitled to $25 an hour, and they cut your pay. That's a big problem, right? That's basically a contractual term that they buried in a policy. If they have a policy saying how you call in sick from work, I don't think consideration really comes into it. They're trying to inform you about what it is. But a lot of policies deal with bonuses, so they might change the bonus structure. So part of the issue that we see in court a lot is an employer will say, well, listen, I posted on my intranet, I posted the bonus policy that said that if you're terminated, you don't get paid the bonus. And people will say, well, firstly, I wasn't told it was on the internet. Even if I didn't read it. And even if I had read it, no one ever asked me if I agreed to it, right? And courts agree. They're like, yeah, well, those are all important steps. You got to do that, employer. And because you didn't, this person is now entitled to their bonus, even though they've been terminated. All right, we got another question from Rob on Facebook. My company has been taken over, and I was sent an employment group benefits package and told to choose an option by Monday. I haven't received an employment letter yet and don't want to sign anything in case it would jeopardize my compensation. What do you do in those circumstances? All right, so basically it seems that your employer is continuing your employment, right? So they want to continue your employment. This is one of those cases where less is more. Having a written employment contract is probably not going to be in your best interest. If you didn't write the contract, it's probably not in your interest, all right? That's just a general rule of thumb regarding contracts in general. But essentially, I go ahead and pick your benefit plan. Basically, by not presenting you with new employment terms, they are agreeing to take on your old employment terms. All right. So in this case, I think you're good, right? We tell you to call us when they're presenting you with something new to sign, not when they're not presenting you something to sign, because like I said, there's like a constellation of rights that are there to protect you. In terms of choosing a new benefit plan, if you don't sign, they're going to put you on the basic plan or whatever the default plan is, which may or may not suit your needs. So you want to choose the one that you want to have. And basically, if they're taking on your employment from your former employer, then that's golden. Your years of service, if you're in Alberta, will be recognized along with that. If they decide to terminate you very quickly, and you have a claim against your former employer for your severance period, all right. So basically, that's something that you need to know. Your former employer is not off the hook. If they present you with a letter saying, well, listen, we're going to take over your job, but only if you agree to release your former employer from any lawsuits, that's when you got to speak to us. All right. That's important that you only sign a release once you've consulted a lawyer, once we have all the facts. But choosing a benefit plan, I think you're fine. All right. All right. I got a call from a question from Tracy Krengle. How long does it normally take to settle a wrongful dismissal claim? Are the courts busy? Well, Tracy, yeah, the courts are quite backed up, unfortunately, now by COVID. So essentially, what I generally tell my clients is basically, if we can settle your matter prior to starting a lawsuit, we're looking at 2-3 months to settle your matter. When matters go to litigation, when we start a lawsuit, then it does take longer. Now, right now, courts in Alberta are quite backed up due to COVID. They're slowly reopening, going through the backlog that they had there. Nevertheless, I can tell you 99% of cases will settle prior to a trial. So during the time that, you're building your way until getting a trial date, there's a lot of work that's done behind the scenes by your lawyer in moving your matter forward and preparing your matter to be ready for a trial. And all these steps are occasions for the for the parties to settle. So basically, there's a few steps after you've started a lawsuit, and lawyers are always working, picking up the phone and using back channels to the other lawyers, to the company, to see if we can reach a deal, because that saves time and expense for both sides, right? We all want to get a quick deal because it's better for our clients. But at the same time, employers start to realize, well, listen, are we going to really pay someone, our lawyer, month after month? When we can settle this matter for a reasonable amount. So that's basically how things are playing out. But yes, I mean, unfortunately, something we are dealing with right now is the delays that have been caused by COVID in the courtrooms and courthouses that had to close down for a long period of time. Sun Ray asks, can an employer change terms and conditions of a contract after it's signed? Mine said after she hired me to give her what I considered to over the top information on myself, such as 3 references, etc. That is weird, right? I mean, basically, they shouldn't send you an employment contract if they haven't hired you yet. Now, some employment contracts will make the job contingent on passing some sort of background check. It could be, security, criminal background checks, and all of that. Also, checking with 3 references. It is a bit odd that they check the 3 references. The challenge with that, though, is if, say, for instance, you don't provide the references and she revokes the offer of employment. So there is a breach of contract there, but the question is, what do you do about it? You don't have a lot of severance because you didn't even start at this job. So you might have a stronger claim if you left another job to take this job, if you moved from another city to this city. But if basically you were looking for work and now this job that was close to fruition falls through, it might be that she did something wrong, but that the damages that flow from that are not huge. All right, so it's something to keep in mind. All right, I have a question here from Bruce Bob Trotter, how do you rationalize to yourself defending someone who is obviously guilty, like Johnny Cochran defending O.J. Simpson? We all knew that O.J. was obviously guilty. Cochran should be ashamed of his job. So, Bruce, I just want to let you know this is an employment law show, all right? So we talk about employment law, people who are dealing with employment law issues at work or once they've been terminated or anything like that. So guilty is really something that arises in the criminal context, all right? Now, there's no real need in an employment law show to go into the criminal law. But yeah, basically, if you have employment law questions, we're happy to answer them. We represent all our clients vigorously because we do feel that they have entitlements. Thank you for your support, Tracy. Tracy adds, Bruce, get a grip. This is an employment lawyer. Thank you, Tracy. Lisa H. asks, thanks for answering my question, Lluc. The occupational therapist is pushing me to agree to a return to work plan. I am not ready yet. My LTD is up in December. My doctor hasn't recommended it yet. All right. Yeah, so that can happen essentially where you have several, medical professionals going in different directions. I don't have the training or the capacity to tell you which medical professional is right. Basically, I would refer you back to your doctor. I can speak from experience that I think that the LTD is going to rely on whatever is most beneficial to them, which is getting you back to work. I don't do disability law myself, but we have a lot of lawyers at my firm that do. So if you're being cut from your disability and your doctor is on your side that you should remain on LTD, reach out to us because we can help you with your LTD claim as well. So I think the website address for the disability lawyers, actually, if you contact us at employmentlawyer.ca, even though your question is not about necessarily employment rights, but about disability rights, we will direct you to the right person to speak to. All right, so you can contact us with help if you're having a dispute between your medical professionals on who's right, whether you're able to return to work or not. So reach out to us. We need to get a bit more detail about what exactly is being recommended by whom, and if you do get cut from LTD, we can step in and help. All right. So Sunray's following up. Yeah, you've signed the contract. Yeah, and then they ask for the references after. It's in my view not the best practice for how to hire someone. You want to check references before you offer them an offer of employment. Like I said, though, I think they did something wrong here, son. But the question is, what damages flow from that? So it is potentially that you're owed damages, including severance and termination damages, but they won't be the same as someone who hasn't even worked one day in a job as someone who has worked 20 years in a job, of course. So that's kind of the practical limitation of your situation. As I said, though, if you've kind of had to move cross country or if you left another job for this job, then you might have a claim. So definitely, if either of those scenarios are true, then you should reach out to us and we can talk to you about how we can help. Again, the website to reach us is employmentlawyer.ca. We talk a lot about severance on the show. If you have any questions, if you're wondering what kind of severance you're entitled to, we have a severance pay calculator on our website, and that severance pay calculator is at pocketemploymentlawyer.ca. You have the website address up on the screen there, pocketemploymentlawyer.ca. It's a great little app. You answer 4 basic questions, and it will tell you how much severance you're likely entitled, both in terms of months and in terms of monetary. All right, it's a completely confidential app. You don't have to, put in your name or your email to use it or anything like that, and you'll get at least an understanding of what your entitlements might be. All right, Bill Sullivan is following up with reference policy manual question. Employer says at their discretion, they can relocate your workplace location, right, to another part of town. Okay, well, that's precisely, thank you, Bill, for that, because that is precisely something for which you would need consideration. You're absolutely right, Bill. So generally, as I mentioned earlier in the show, when you don't have an employment contract, there are certain unwritten terms that apply to every employee. All right. And one of those terms is that basically your work location, it's important to know that your employer can't say, well, okay, we're closing down your work location here in Calgary, Alberta. We're moving it to Toronto. You want your job, move to Toronto. You don't want to move to Toronto, we're going to say you quit. You didn't quit. You were constructively dismissed. All right. You were constructively dismissed, your own severance. Now, work location changes can be a constructive dismissal, and sometimes they're not. Of course, if they move right across the street, doesn't change your commute at all, hard to say that it's a constructive dismissal. And it doesn't have to be from Calgary to Toronto. It could be from, say, one end of Toronto to the other. If you're working on the east side of Toronto, say in Scarborough, and now you have to work on the west side, say in Mississauga or Brampton, I mean, the commute in itself is probably only about 40 to 50K. But through traffic, that can add another hour and a half, 2 hours to your commute every day, each way, right? So now basically they're saying, well, you're still working in Toronto. I don't see what the issue is. Yeah, but you're traveling 4 more hours a day. Of course, that's a constructive dismissal. You need my agreement to do that. If, however, some policy manual says somewhere that you will agree, that I agree to be relocated no matter what the circumstances are, and that's not a constructive dismissal, then you might be in trouble. And then you have the issue, Bill, as you raise, of lack of consideration. I would probably tell them, listen, I'm not going to sign this policy manual, or if you want me to sign it, you got to take out this relocation policy. I don't agree with it. All right. Because policies are just supposed to be like, policies, right? Instead, people use that to, slip in an employment contract into a written employment contract, into a contract where into an employment relationship where there was no written employment contract, right? And so, consideration will be whether you receive something in exchange for agreeing to this term is going to be important to the courts. Jesse Voss asks, would I be able to receive any compensation for this accident? So Jesse was referring to going back to work from LTD. Jesse, it might be that you're owed some sort of compensation if you were involved in some sort of vehicle accident. Reach out to us. I'm not the expert on this. We actually also have a disability show that comes on every week. So you might want to tune into that, or simply call us at employment, or reach out to us at employmentlawyer.ca. We'll put you in touch with someone in our disability team. We'd be happy to speak with you. We got a question from Mark here. My employer has been unwilling to give us any clear details on if we will continue to work remotely or return to in-office. How long do I have to wait to find this out? Actually, this was the second topic I wanted to bring up with you today. So a lot of people are being recalled to work. Elon Musk is recalling everyone at Tesla to come back to work. Basically, in terms of how long you'll have to wait, Mark, I mean, that's kind of up to your employer. What you want to figure out is whether you have to go back to work, all right? So there are certain circumstances in which, again, as we were talking about with Bill, a change in location can be a constructive dismissal, and potentially being forced to go from home, working at home, back to the office is just like a change in location and can amount to a constructive dismissal. So, of course, if you were always working from home, if you got hired during the pandemic working from home, if you were working from home prior to the pandemic, then being forced to go back to the office could be a constructive dismissal. If during the pandemic, the employer said, well, listen, we're going to allow you to work from home indefinitely, and all of a sudden they're changing their mind and saying, okay, we take that back. We don't want to do that. You got to come back into the office. That promise could be constructive dismissal, especially if you rely on it. I had a woman basically talk to me about how she had been told she could work indefinitely from home following the pandemic, went ahead and sold her house and moved further away from the city. And now she's being asked to go back to work. And so her commute, which was maybe half an hour, will now be 2 hours each way. Well, I mean, it's the employer that promised her that this would be a permanent move. You're allowed to rely on your employer's promise. So your employer is now on the hook for severance. Randolph Butternubs, good name. Randolph asks, do provincial changes to minimum wage allow an employer to change or lower your pay without any consideration? So no, I agree with you, Randolph. It's not because the minimum wage has gone down apparently for students here in Alberta. It used to be $15 an hour, now it's 13. Generally, though, the trend in minimum wage is that it goes up. Right, so this is a very weird move by the provincial government here, especially considering there's a labor shortage. I mean, what are you're going to pay people less in a labor shortage? I mean, it doesn't make a lot of sense. Usually, if there's a labor shortage, wages should go up. You shouldn't be cutting minimum wage. It doesn't make a lot of sense to me. But in any case, if you were one of those employees that was earning $15 an hour and now you're being paid $13 an hour, you can treat that as a constructive dismissal potentially. So for a change in salary to amount to a constructive dismissal, we're looking at a change of about 12 to 15%. So I'm trying to think. I can't do the math right off the top of my head, how much a $2 change amounts to. But if it's 12 to 15%, which it should be, then that's a constructive dismissal. And the employer who changes that, makes that cut, is not really thinking smartly, because there's tons of other employers that need student help that are willing to pay $15 an hour or more. So they're just going to lose all their staff. All right, everyone. That's the show today. My name is Lluc Cerda. I'm a senior associate here at the Calgary office of Samfiru Tumarkin. I'm the managing associate of the Alberta office. We have shows coming up every day this week, including tomorrow. So if I haven't been able to answer your question, tune in tomorrow. We'll have more time to discuss your matter at that time. Thanks for tuning in, and thanks for all your questions.